Hello, everyone, and welcome to Uncivil Law. For today's case, we are talking about guilty pleas without admitting that you actually did the crime. This is known as a no contest plea, but it's not always authorized by law in various states. But the U.S. Supreme Court had to deal with this case in a case called North Carolina versus Alford. In this case, Alford pleaded guilty to murder, but he denied committing the crime. So the federal government has to consider whether it's legal for its purposes. Let's get started with this. On December the 2nd of 1963, Alford was indicted for first-degree murder, which was a capital offense under North Carolina law. The court appointed an attorney to represent Alford, and this attorney questioned all but one of the various witnesses who Alford said would help him. But no, the witnesses did not support his story, but instead gave statements that strongly indicated guilt. Faced with the evidence of guilt and no substantial evidence for support of a claim of innocence, Alford's attorney recommended that he plead guilty, but he left the ultimate decision to Alford himself, which I don't know if this is true at the time this was decided, although I'm pretty sure it was, but this isn't exactly a choice that was left to Alford. It's Alford's choice fundamentally. Like the client does have some fundamental choices, like whether to plead guilty or not would be one of those fundamental things. So it's not like, his attorney could say, we plead guilty. That's not how that works. The prosecutor agreed to accept the plea of guilty to the second-degree murder, and on December the 10th of 1963, Alford pleaded guilty to this reduced charge. Before the plea was finally accepted by the trial court, the court heard the sworn testimony of a police officer who summarized the state's case. Two witnesses besides Alford were also heard. Although there were no eyewitnesses to the crime, the testimony indicated shortly before the killing, Alford took his gun from his house, stated his intention to kill the victim, and returned home with the declaration that he had carried out the killing, which sounds, kind of suspicious, yes. After summary presentation of the state's case, Alford took the stand and testified that he had not committed the murder, but he was pleading guilty because he faced the threat of the death penalty if he did so. So he denies that he committed the crime. The trial court then asked the appellee if, in light of his denial of guilt, he still desired to plead guilty to the second-degree murder, and appellee answered, yes, sir, I plead guilty from circumstances that he, that would be the attorney, told him. Okay, so again, this is an option that is provided for by some states in some instances where this is a no contest plea, no contendere plea. And so you can plead guilty or not guilty. And some states allow no contest, but some states don't allow it. And there is an idea that you have to plead guilty, but some states will do allow you to say not guilty, or to say that I'm just accepting liability. And so, this particular situation, there's this question as to whether or not the federal law allows for this, whether or not, especially in these circumstances, whether or not this is a voluntary plea, whether or not you can say, yeah, I'm accepting responsibility, but not admit to the crime. So the Supreme Court has to deal with whether or not this is constitutionally acceptable. Let's get started. Let's discuss a little bit more. If the person is legally insane, can't the attorney not allow a guilty plea? Well, the person is legally insane. Well, it depends a little bit what we mean by the question. There's two different scenarios. When you say someone is legally insane, the question is when. Are they legally insane now, or were they legally insane in the past? Because those can be different things. If they're legally insane now, then the question might be whether or not they're competent to stand trial. So that would be a problem. If they're legally insane in the past, but they're sane now, then no. If they're legally insane now, the question might be, why are we doing this trial at all? Because they're not competent. You have to be competent to stand trial. So I'm not sure about your question. But if the client is competent, then the client gets to make those decisions. If the client's not competent, then why are we at trial? So I don't think so, no. Alford sought post-conviction relief in the state court. Among the claims raised was the claim that his plea of guilty was invalid because it was the product of fear and coercion. After hearing, the state court found the plea was willingly, knowingly, and understandingly made on the advice of counsel and in the face of a strong prosecution case. So he argues, in fact, it was at least coercive, but the state court disagreed that there was coercion sufficient to override the plea. We held in Brady that a plea of guilty which would not be entered except for defendant's desire to avoid the death penalty and to limit the maximum penalty life imprisonment or term of year was not for that reason compelled within the meaning of the Fifth Amendment. Jackson established no new test for determining the validity of guilty pleas. The standard was and remains whether the plea remains a voluntary and intelligent choice among alternative courses of action open to the defendant. All right, so this is one of those sort of legal logic problems that really sort of makes you think and makes you try to figure out what exactly you believe in. Because the concept of this truly being a voluntary choice is problematic. It's problematic in any case because the state always has the threat. They always have the threat of higher sanction, and particularly when death is on the line. So normally, if someone is threatening you with something in order to get you to do something, you're thinking extortion, you're thinking blackmail. But there is, at least in this context, there is this idea that just because the state is threatening penalties up to and including the death penalty, that doesn't make it inherently coercive. Which, if you thought about it logically, in terms of how that would apply in the real world, it's a little bit weird because normally, if someone has a gun to your head, you think of that as a coercive. So the only thing that sort of changes that logic is that the gun to your head won't fire for a period of years, because even if you're convicted of and given the death penalty, that's not going to happen for a long time. So maybe it's not coercive because you have more time to think about it, but still, like, your life is on the line or freedom is on the line. That's not coercive. So it's one of those like logical problems that and doesn't really feel adequately solved. But a person can choose to plead guilty for a whole number of reasons, and one of those reasons might be less time, and they're fearing more time. So the courts. I mean, this has always been a tension, right? Whether or not a person is coerced or not, and you think, aren't they suffering the penalty of going to prison or death penalty if they say no? But the courts see that's not coercive in itself. I guess the reason is because you have an attorney, you have time to think about it, stuff like that. But that's a bit of a logic problem if you really think it through. So at least the Supreme Court has said that just because you're threatened with a death penalty, and you choose a life imprisonment term instead, does not mean that you were coerced into it. So whether or not you buy that on some fundamental level or not, I mean, that's the law. So we can speak authoritatively to that, whatever the ethics issues are. That he would not have pleaded guilty except for the opportunity to limit the possible penalty does not necessarily demonstrate the plea of guilty was not the product of a free and rational choice. I don't know. Especially where the defendant was represented by a competent counsel whose advice was the plea would be to your advantage. Okay. As previously recounted, after the plea of guilty was offered and the state's case was placed before the judge, Alfred denied that he had committed the murder but reaffirmed his desire to plead guilty to avoid the possible death sentence and limit the penalty to a 30-year maximum provided for in the second-degree murder. Ordinarily, a judgment of conviction resting on a plea of guilty is justified by the defendant's admission that he committed the crime charged against him and his consent that the judgment be entered without trial of any kind. The plea usually subsumes both estimates, and justifiably so, even though there's no separate express admission the defendant has committed the particular act claimed to constitute the crime charged in the indictment. If Alfred's statements were to be credited as sincere assertions of innocence, then obviously existed a factual and legal dispute between him and the state. So if he was saying, I'm actually innocent, then there are disputes as to fact and law. I didn't do it, and I'm not guilty. I didn't do it is a factual conclusion. I'm not guilty is a legal conclusion. So if you're saying, I didn't do it, I'm not guilty, that's both a factual and legal dispute. Without more, it might be argued that the conviction entered on his guilty plea was invalid, since his assertion of innocence negated any admission of guilt, which, as we observed, is normally central to the plea and foundation for the judgment against the defendant. So, yeah, normally the court wants you to admit to the facts. If there's a dispute as to facts, then go to trial. But because there's penalties usually associated with that, more charges, more penalties, longer terms, most pleas end in guilty. I forget exactly what the statistics are, but something like 92% of federal cases end in a plea. Someone will fact check me, I'm sure, if I'm wrong, but it's something in that magnitude. It's like 92% end in a plea. And the reason 92% end in a plea is because the state is usually offering to take off charges, offering to provide less penalty. So they're normally saying, well, if you go forward, we're going to charge more stuff, but you can settle now for this lower charge. And, most people take the deal because of the coercion. And so it's like, what's the legal posture on that? What's the ethics posture on that? What is the certainty posture on that? And there's a whole host of considerations there. And you could also argue, of course, that a person's probably guilty of something, even if they're not necessarily guilty of this, which may sound a little dismissive on one end. But, it's pretty unusual for a truly innocent person to truly come to jail. Usually you're guilty of something even if it's not what the state quite charged. So maybe there's some sort of balance in that. But you can argue the ethics points for days. As to the legal issues, though, if you want to plead guilty, then it's your choice, even if you are being coerced, but it's not coercion in a legal sense because we've decided it's legally acceptable. So, that's where we are. State and local federal courts are divided upon whether a guilty plea can be accepted when it is accepted by protestations of innocence and hence contain only a waiver of trial but no admission of guilt. Some courts, giving expression to the principle, our law only authorizes conviction where guilt is shown. So there are definitely courts and definitely states which do not allow this and certainly don't allow it in particular contexts. So sometimes it's allowed in some contexts and not others. But others have concluded that they shouldn't force on any defense a defendant a criminal case, particularly where the events of the defense might end in a disaster. They've argued that since guilt or degree of guilt is at times uncertain and elusive, an accused, though believing in or entertaining doubts respecting innocence, might conclude the jury would conclude of his guilt and that he would fare better in the sense of pleading guilty. As one state court observed nearly a century ago, reasons other than the fact that if guilt may induce a defendant to plead, and he must be permitted to judge for himself in that particular respect. The issue in a prior case was whether a federal court has the power to impose a prison sentence after accepting a plea of noli contendere, a plea by which the defendant does not express an admission of guilt, but nonetheless waives a right to trial and authorizes the court for purposes of him as though he were to be guilty. The court held a trial court does have a power, and except for cases that were rejected in the prior case law, the federal courts have uniformly followed the rule, even in cases that involve moral turpitude, which is to say a moral failing, a moral guilt, which, murder would certainly qualify as an example of that. So the court here is dealing with the no contest plea and whether or not that's valid and prudent. And the court says that, it's valid. Some states disagree, and that's a province of the state law to disagree. Some states don't allow it, and they don't have to. But a no contest plea is allowed if you can. And, it just says the federal courts have done this. So even if it's something that would involve a moral failing, murder being a prime example, then you can still plead to it if you think that you can't win. If you get a better deal, it's your decision to make. And again, whether that's coercive or prudent or ethical, we're dealing with law. And I've often said on this channel that law is not ethics, is not moral. By which I mean it's different from those domains. We can ask moral questions, we can ask ethics questions, and we can ask legal questions. Legal questions are different from that domain. So what the moral implications are, what the ethics implications are certainly interesting and I think worthy of discussion. But in terms of what the legal implications are if the relevant state authority or relevant jurisdiction allows it, then you can have no contest pleas, and that is a thing that is valid, at least as far as the U.S. Supreme Court is concerned. These cases would be directly on point if Alfred had simply insisted on his plea but refused to admit the crime. The fact that the plea was demonstrated by a plea of guilt rather than a plea of no contest or noli contendere is of no constitutional significance with respect to the issue before us, for the Constitution is concerned with the practical consequences, not the formal categorizations of the state law. So if the state law allows for it, we're not concerned with formalities, we're concerned with the consequences. So as is true in many places in law, we're not necessarily concerned with what is on the label, we're concerned with what it is, and as long as it is what it is and you know what you're doing, then it's fine. Thus, while most pleas of guilty constitute both a waiver of trial and an expression of guilt, the latter element is not a constitutional requisite to the imposition of a penalty. An individual accused of a crime may voluntarily, knowingly, and understandingly consent to the imposition of a prison sentence, even though he's unwilling or unable to admit his participation in the acts constituting a crime. Thus, that brings us to the end of the case of North Carolina versus Alfred, which stands for the proposition that no contest pleas or noli contendere, to put it in proper parlance, are authorized if they can be provided by law. They don't have to be, but they can. And so there was no error here for the court to allow for an effective no contest plea. Technically, the guy did plead guilty. He pled guilty. But in practice, it was no contest plea. And the court says, well, you may call it a guilty plea, but it was in effect a no contest plea. But no contest plea is an admission to liability anyway. And that is a decision that you can make regardless of what you think the ethical implications might be. Because whether or not it's coercive, if we're threatening you with a death penalty, might be an ethics consideration, but ethics is not law, So, for the moment, that brings us to the end of the consideration of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.